panel with a welcome from our new Chief Justice, Chief Justice Wayne Martin, who unfortunately can't be with us. He has committed to Australia. So hence that screen you'll see in front of you, I hope will be filled at the moment with his image, and he'll be speaking to us live from Australia. Good morning, Chief Justice. Can you hear me?
Good morning, Judge Black. Very nice to be with you. I hope everybody can hear me and see me okay.
We can hear and see you okay. I wonder actually if we could make the Chief Justice's image bigger and take off the other window. But Chief Justice, if you'd like to begin, we can certainly hear you.
Certainly.
Hear and see you anyway.
Excellent. Well, thank you very much, Michael. It's a great pleasure to be joining Dubai International Arbitration Week, albeit only remotely this year. I very much hope to be present in person next year. It's also a great pleasure to welcome everybody to this seminar, which is being presented on behalf of the DIFC Courts. A number of commentators have observed that the DIFC Courts were the first of their kind and created a new model for dispute resolution, which has been emulated in different ways and in different places around the world. The DIFC was the first place to set up a commercial legal system specifically designed for international trade and commerce, picking out and assembling best practice laws from different jurisdictions around the world and putting them together in one place. The DIFC Court has also been designed to adopt best practice, drawing on experience from different jurisdictions, unconstrained by long established practices or protocols. The DIFC Courts were the first in the world to open their doors to litigants from anywhere in the world, the only jurisdictional requirement being that they agree in writing to resolve their disputes in the court. The court's also been quick to embrace technology, given its importance to a truly international court, with litigants, lawyers and judges in different countries and different time zones. And I'm not talking here just of communications technology, but also other areas of technological change. The court has heard a significant cryptocurrency dispute and broken some new legal ground in this area. And the DIFC digital assets law is at the cutting edge of legislation in this emerging field. So as a court, we hope to help more parties to resolve digital currency disputes in the future and to establish the court as a centre of excellence in this area. We're hoping to do the same in another developing area, not just in relation to international disputes, but indeed extraplanetary disputes which arise in space. Of course, those disputes are not within the boundaries of any country or any court, or even on the planet. And I'd like now to move to the topic of today's seminar, which is the multi-door courthouse. And I'll explain what I mean by that expression in a minute. But I'd like to start with what I call the ADR misnomer. And ADR, of course, is an acronym that everybody understands to stand for Alternative Dispute Resolution. And the word alternative suggests that methods other than court resolution are some kind of weird alternative to the mainstream of dispute resolution, which is litigation in a court. A moment's thought, I think, will reveal how erroneous that impression would be. If we consider all disputes that arise between human beings and the mechanisms that are used to resolve those disputes as a kind of a pyramid going up to a zenith at the top, you can see that other methods of dispute are much more common. Of course, courts have only been around for the last couple of thousand years at the longest, whereas human race has been around for much longer than that. And so humans developed techniques for resolving disputes long before courts were invented. Those techniques have involved negotiation, discussion, and of course, in early days, unfortunately, by resort to force, although hopefully those days, I think, are well behind us. But today there are many different systems by which human beings resolve their dispute, by talking to each other, by getting somebody else involved to talk to the disputant. There are complaints handling mechanisms in most organisations. There are consumer affairs agencies that help resolve disputes by consumers, and digital systems for dispute resolution have emerged using the technology. And so some years ago now, eBay, for example, used its digital dispute system to resolve some 6 million disputes a year. There are ombudsmen, there's arbitration, there's mediation, there's conciliation, there's facilitation, there's expert neutral evaluation, and there's expert determination. And if you think about the numbers that are in those other areas and go back to our notional pyramid, I think you'd agree that the court is at the very top of that pyramid in numerical terms, possibly the last stone at the very top of the pyramid, in relatively small numbers compared to many of the other systems for dispute resolution that exist in different societies. So in that sense, resolution of disputes by litigation is itself the exception rather than the norm. And so it's my view, and this is not a novel view, it's been expressed by many others, that the A in ADR should be taken as meaning appropriate dispute resolution. That is, by selecting the method that is most appropriate for that particular dispute and for those parties. Now, of course, even those disputes that go to court, only a very small proportion of those are resolved by trial. In my former court in Australia, and indeed most Australian courts, the percentage of cases that go to trial amongst those that are initiated in the court is less than 2%. And that's quite common in other developed economies as well, including the United States and the United Kingdom. So only a very, very small percentage of disputes are actually resolved by a trial in front of a judge or a court. So in that context, let's move to the multi-door courthouse. What I mean by that expression is a courthouse in which the court actively encourages parties to consider and utilise other methods of dispute resolution that are suited to their particular dispute and their particular circumstances. Now, some critics of the expression multi-door courthouse have suggested that it implies that curial determination is just another product on a shelf of products from which parties can choose, depending on their tastes and budget, whereas courts are qualitatively different from other methods of dispute resolution because they speak and act with the authority of the state. They establish norms of behaviour and conduct which are acceptable in the society of which the court is a part, and norms of behaviour and conduct which are not acceptable within that society. Courts are essential for the maintenance of the rule of law and have a constitutional dimension, and courts also have coercive powers which can be used to enforce their orders and decisions. And so in this respect, courts are so different from other methods of dispute resolution that it's erroneous to lump them in the same bundle. Now, critics of the expression along these lines include a former Chief Justice of Australia, who is now a valued colleague on the DIFC Courts. And of course, he's right in the sense that courts have all of those characteristics which are unique to the judicial function and are not characteristics of any other form of dispute resolution. However, in my view, that doesn't mean that courts can't perform their important functions in a context in which most parties want their commercial disputes resolved as quickly and as cheaply as is possible, consistently with a fair and just outcome. The place of courts within the constitutional framework for the governance of a country is unlikely to be high on the list of matters for consideration when a party is attempting to recover money said to be owed under a commercial contract. And of course, if the dispute has an international dimension and the party wants to be able to enforce payment against a party or assets in another country, a domestic court is likely to be of limited assistance compared to the enforceability which international arbitration provides through the New York Convention. So, while recognising the important characteristics of curial determination as compared to other methods of dispute resolution, we at the DIFC Courts can see no reason why we shouldn't actively encourage parties to use other methods if they choose and to operate as a multi-door courthouse in that sense. Now, to try and indicate just how that might work in practice, it's appropriate to give some consideration to the different types of appropriate dispute resolution. And they can be basically categorised into two broad categories: adjudicative methods and consensual methods. Adjudicative methods, of course, involve a determination by a third party, and they include court determination, arbitration, and expert determination. Court determination depends upon the court having jurisdiction, whereas arbitration and expert determination depend upon the agreement of the parties. Although, as I've already mentioned in the case of the DIFC Courts, a written agreement is all that is required to confer jurisdiction upon the court. If there is an arbitration agreement, of course, courts in any jurisdiction adopting the UNCITRAL model law must stay any court proceedings upon the timely request of any party to the arbitration agreement. The model law basically requires the court to facilitate and support arbitration, and the DIFC Courts take that obligation very seriously indeed. Even the most superficial review of the decisions of the DIFC courts quickly reveals the courts to be arbitration friendly, in the sense of being supportive of arbitration without being interventionist. And you'll hear more on this topic from the very experienced judge in charge of the arbitration division of our court, Judge Shamwan Al-Sawali, later in this session. In relation to consensual forms of dispute resolution, the most significant of those is, of course, mediation, and I'm a great supporter of mediation. Time doesn't permit me to tell you all the reasons why, and I've been an active mediator for more than 20 years, including the 12 years I spent as Chief Justice of Western Australia. That court has a court-based system of mediation utilising registrars and mediation-trained judges. It's been compulsory in practice for more than 30 years, in the sense that the court is very loath to give parties trial dates until they have mediated. Success rates at mediation have been consistently high, with about 2/3 of cases settling at or after mediation. And without that rate of settlement, the court simply could not have discharged its caseload in a timely fashion without much greater judicial resources, which government was unlikely to provide. The DIFC courts currently provide mediation by registrars, primarily in the Small Claims Tribunal, although it's not limited to that tribunal. But I'm pleased to announce that work is in hand to create a mediation centre, the purpose of which is to expressly and actively encourage all litigants in the court, whatever division of the court they happen to be in, to consider mediation. And the current rules of court provide case managers with the power to do just that. I doubt that we will ever get to the point of universal or de facto compulsory mediation, as in my former court in Australia. The international nature of the court's business and its clientele is likely to preclude that, but we certainly want to see greater use of mediation. I'll now, having hopefully opened the topic for others, I'll now hand over to other speakers who will say more on these and other subjects. So thank you very much for your attention.
Thank you very much indeed, Chief Justice, for that overview and introduction to what we are going to deal with on the live side today. And can I just again add a few words, if I may, to the theme in supplement to what the Chief Justice has told you. The theme is, as we say, the multi-door courthouse, or MDC as it's sometimes known, and we'll come to a court which is known by that acronym actually in Lagos in Nigeria. But the origin of it goes back, in fact, to a concept invented by a professor at Harvard in 1976, Professor Frank Sander. And indeed, I was very privileged to take a course at Harvard under Professor Sander himself. I know that Satner took the same course, but sadly, I think after Professor Sander had retired. And he first raised the issue of the multi-door courthouse as long ago as 1976 at a conference called the Pound Conference of 200 influential US judges and lawyers. And he said this: "We've tended to assume that the courts are the natural and obvious dispute resolvers. But he said, as our Chief Justice has said, there's a variety of processes which he said may provide more effective conflict resolution." And Sander outlined the categories of criteria for determining the resolution mechanism for each type of dispute. And he postulated 5 criteria which have become very well known. 1, the nature of the dispute. 2, the relationship between the parties. 3, the amount of money involved in the dispute. 4, cost, which has been interpreted as both the amount of the claim and the cost to pursue the claim. And 5, speed, which has been interpreted as both the desire for quick resolution and the need for urgent intervention. So as the Chief Justice said, ADR does not mean alternative dispute resolution. It means the most appropriate resolution following Sander's criteria. And we started to do that in our own way in the DIFC courts. The court on which I sit as a judge in charge, the Digital Economy Court, is to act as something of a sandbox to use the appropriate expression, I guess, for digital economy, in procedure. What we've done is to try to get the parties as quickly as possible before the court, and then the judge will hold the first CMC and decide the most appropriate means of resolving that particular dispute. It could be arbitration, it could be early neutral evaluation, it could be any of the armory of dispute resolution procedures that we're going to discuss in a moment. So with that, I'd like very much to introduce our distinguished panel. And forgive me if I take you in a slightly different order than they're sitting. So first of all, I'm sure everybody knows His Excellency Justice Shamnan, who is head of the DIFC Courts Arbitration Division. Justice Shamnan has perhaps a unique perspective on the arbitral landscape in the region and the interaction between arbitration and the courts, on which he'll speak in a moment. Next, if I may, is to take you to somebody who's been well known to some of you who practiced for some time in this jurisdiction. She was a practitioner before these courts and in arbitration before she moved to Singapore. She was appointed King's Counsel there. She practiced in Singapore as counsel, arbitrator and mediator, and became, I think, the second ever and first woman English KC to be given rights of audience before the Singapore courts. She then joined the Attorney General's chambers in Singapore. That happily for us, appointment has just ended, and so we were able to appoint her as a justice of our courts, a member of the Court of Appeal. She's in limbo at the moment. The decree has been signed, but she's not sworn in. So she is Justice Statner, but she's not allowed to hear any cases yet, not until the 28th of this month. Anyway, and I hope you don't mind me saying this, Statner, but she is by some way the youngest member of the court, which means that you're going to have the privilege of appearing before her for at least the next 20 and even longer years. So the concept of the MDC, multi-door courthouse, has been tried in several jurisdictions, but leading the way has been Nigeria, and it introduced the Lagos MDC as long ago, I think it's 2002. It's been enshrined in legislation in 2007, and that legislation, the LMDC, Lagos Multi-Door Courthouse Act, was updated in 2015. And we are hugely privileged to have someone who can tell us all about it and indeed talk to us about ADR on a global scale. Professor Emilia Onyema is Professor in International Commercial Law at the School of African Oriental Studies, SOAS, University of London. She is a world-renowned practitioner in international dispute resolution. She has published and spoken extensively on the topic with a particular expertise in sub-Saharan Africa, being Nigerian herself. And she even finds time occasionally to sit as arbitrator, and I'm privileged to be sitting with her on an arbitral panel in relation to a dispute from this region at the moment, and she is a member of many panels, including that of DIAC. And last but not least, particularly visible presence.
God is great.
It is James McPherson. James is thoroughly embedded in the world of ADR, both in this region and internationally. He was instrumental in founding both the Saudi Center for Commercial Arbitration and the Bahrain Chamber of Dispute Resolution. He was an inaugural board member of the Oman Arbitration Center, and he has more than 30 years of experience within the public and private sector as mediator, facilitator, arbitrator, ADR trainer, advisor, and systems designer. He now heads up an outfit called Gulf Mediation, which is based in the ADGM, but I'm willing to forgive him for that. But as I say, he has a magisterial knowledge of dispute resolution within the region. So having said that, and having introduced our distinguished speakers, can I first of all invite Justice Shamlan to give us some overview of the interaction between arbitration and the courts, and how the courts have facilitated, as our Chief Justice said, the practice of arbitration in the region.
Thank you, Michael. Assalamu alaikum, hello everyone. Welcome for, I think this is, Michael, the third or fourth time we do the DIFC Court arbitration session during the Dubai Arbitration Week. The purpose for this is to educate everyone about the practice of the DIFC Court and how the DIFC Court actually trying to support the arbitration in this region through the common law remedy exists within its practice. So mainly, if you have your contract and the contract say the seat is DIFC, what does that mean? That means you're going to approach the DIFC court even in early stage before you file your arbitration request, whether it's with the LCIA or ICC or any arbitration institution. If you need this kind of urgent remedy, you will apply it for us within short time. I would say within 24 hours, we can give you the interim remedy you are looking for, whether it's like a freezing order or anti-suit injunction. The DIFC court will be much familiar with those practices, given the fact that most of the judges actually came from the common law, and most of the judges actually sit as an arbitrator themselves. Myself, I sit as an arbitrator in my own time, which is I was very pleased from my previous Chief Justice Michael Wang, who gave me that exception, and I learned even from that job. When I sit as an arbitrator, and this is what makes me a judge in charge for arbitration. So the idea is you will choose a seat for your arbitration within this region, a seat. And you will choose, can get those of remedy which is not exist in other jurisdiction on onshore courts, whether even in UAE, Dubai, or Saudi Arabia, or whatever it is, such like anti-suit injunction or worldwide freezing order. Those type of remedies not exist in the civil law practice. This is the beauty of choosing the seat. Now, there is another element of the DIFC Court Arbitration Division can help you with enforcing your order, even if there is no any connection with the DIFC. Basically, it's a conduit jurisdiction. It's still under DIFC arbitration law. This is will stay. This is the practice of DIFC Court. So if you got an partial award or final award or interim award in cost or emergency order from emergency arbitrator, you can bring it to the DIFC to be recognized and enforced, even if there is no connection or there is no assets within the DIFC. Whether this practice is gonna be a challenge, we never know. But this is the practice right now, and this is we can help the community. Actually, there is a lot of advantage of DIFC Court being choose a new contract as a seat as a common law practice. You can have your own lawyer to represent the client before the DIFC Arbitration Division, because we don't have kind of requirement for having a lawyer coming from common law background or common law qualified. We can have for right of audience, give right of audience for lawyer came from the civil jurisdiction, if they can, of course, communicate in English and they can prove themselves, they have some practice in arbitration. Cost recovery. This is something very important in this region. If you bring an application to any onshore court in the civil jurisdiction, you will not get that cost recovery you're looking for. All of those advantages which exist in the common law, if you're going to choose, let's say, London as a seat or Singapore or Hong Kong. But on the top of that, you will get an award and a judgment from the DIFC Court, which will be enforceable within this region. So the DIFC Court judgment recognizing your award or a DIFC Court order for interim will be enforced in both ways. Will be enforced within the JCC for the JCC enforcement convention, or will be enforced in the Arab award through the Riyadh Convention. In the top of that, you can take our judgment to a common law jurisdiction and will be enforced without question, because it will be seen as a common law to common law practice. So on the top of that, as I said, if you're comparing our jurisdiction with other common law jurisdiction, you've got all of those advantage and the treaty of common law you are familiar with. I think to be independent as well is very important. So if you've got a business, you want to do a Chinese company, want to do business in Saudi Arabia or in Kuwait or in Oman, or then you have to pick a seat which is a neutral for that deal. You can go the Saudi Arbitration Center 100%, but you can give away the seat to UAE, especially to the DIFC. I think this is something as a key selling point for choosing the DIFC. I can speak about DIFC forever, but actually I don't want to take my colleagues' time, but I'm free to answer any question later on.
Yes. Thank you for that's extremely helpful. And actually, you used less time, so we've been caught up with each other, which is fantastic. So I'm going to move. We'll have questions later. So I'm going to move to Satna, if I may. And Satna, I know this is a topic that you've studied generally. You're really interested in. So the question for you is: how does the multi-door courthouse concept respond to what users want?
So thanks, Michael. I think to answer that question, I think there's two parts. Firstly, what do users want? And I want to be very data-driven when we look at how we answer that question. And secondly, how does the multi-door courthouse deliver what the data tells us that users want? So looking at the data, I want to look at two aspects. Firstly, the data from something called procedural justice theory, which I will explain. And secondly, data gathered from in-house counsel. So procedural justice theory, what is it? It's a theory conceived by Professor Tom Tyler of Yale Law School. And it's a theory based on research gathered from users of dispute resolution processes. And I'm talking about the full range of processes: court adjudication, arbitration, mediation, and negotiation. And the strong findings from that data, which I have to say, I think are a little bit counterintuitive, is that whether a party is satisfied with a dispute resolution process depends more on how fair they perceive the process to be than what the outcome of the process was. So in a nutshell, if I lose a case, but I feel that the process is fair, I'm going to be satisfied. If I'm going to be satisfied, I'm going to accept the outcome. And if I accept the outcome, then I view the process as legitimate. So there's a link between the legitimacy of dispute resolution processes and their perceived fairness. Now, I think it's really important to bear in mind that when we're talking about perceived fairness, we're talking about a party's subjective view. And yet, in international dispute resolution, quite rightly, we are very focused on objective notions of natural justice. And I think there's a little bit of a tension there. So 4 factors have been shown to shape users' subjective perceptions of fairness. Firstly, voice, the opportunity to be heard, no surprise there. Secondly, dignity, being treated with respect and courtesy. Thirdly, neutrality. And fourthly, trustworthiness. Having a sense that the neutral is acting in good faith and has listened and considered the party's views. So it's not enough for a party to be heard. They have to feel that what they say can actually have an impact on the outcome. So why is all of this important? I think we have to have a very user-focused approach, and I think the multi-door courthouse comes out of this. When we're designing dispute resolution processes, we need to consider the lens through which disputants are judging the fairness of the process. And when we're executing a dispute resolution process as a judge or an arbitrator or a mediator, again, we need to put ourselves in the party's shoes where the view is very much subjective. So moving on to the second area of data I want to look at. I'm a member of the ICC Commission on Arbitration ADR. I think you are as well, Michael. We may have other members.
No, I'm ex-officio.
Ex-officio member. And that's a global think tank of over 1,000 members globally that really works and looks at international dispute resolution processes and how to improve them. And I was part of the the Commission's task force on arbitration ADR. and they collected data from users from in-house counsel specifically through various forms, including surveys and open mic sessions, where in-house counsel would grab the mic and tell those on the task force, this is what we think is wrong with international dispute resolution processes, this is what we want to change. There are lots of findings from that task force, but I want to highlight 3 for you. The first is business users want more dispute prevention tools. That includes mediation and early neutral evaluation, which can be used to settle or dispense with claims early. Secondly, they want more dexterity across dispute resolution options. They want a suite of options, and even for the same case, they want to have a more fluid ability to move between different processes. And finally, in-house counsel were asked in a survey, do you want arbitrators, so decision makers, who can encourage or facilitate settlement? That's not necessarily arbitrators who mediate. Arbitrators even saying to the parties in the procedural timetable, do you want a window for mediation? Have you thought about mediation? An overwhelming 78% of business users surveyed said, yes, that's what we want. So how do we pull this together? How does a multi-door courthouse give users what they want based on the data? Well, if we look at the DIFC Courts version of the multi-door courthouse, if users want court adjudication, they can get that. As mentioned by our Chief Justice, the court started operations in 2006, the year I moved to Dubai, convention, so a good 18 years ago, and they have a strong and well-established track record in dispensing justice since then. If they want mediation, they can get that. There's an existing way for mediation to be pursued by parties, but we're now setting up a mediation centre. If they want arbitration, as we've heard from Justice Shanman, the DIFC courts will support and uphold the parties' agreement to arbitrate, even for arbitrations that are not seated within the DIFC. And finally, I just want to mention a couple of points for the future and where we go forward. Once we embrace the idea of a multi-door courthouse and more dexterity between different dispute resolution tools, we can explore more and more creatively how to combine them. Michael mentioned the digital economy court, where you have a case management conference, you talk about what's appropriate dispute resolution. I want to give you just one example from Singapore. There's a collaboration between the Singapore Mediation Centre and the Singapore International Commercial Court, and we're privileged to have with us one of the judges from that court, Justice Bikri, sitting in the first row. And it's called the Integrated Appropriate Dispute Resolution Framework, or INTEGRAF for short. For those of you here familiar with Singapore, we love acronyms. So INTEGRAF is a framework for complex conflicts arising from large projects or large commercial transactions. Under the framework, parties establish a conflict avoidance board appointed by the Singapore Mediation Centre, who will guide the parties through different dispute resolution processes. It can help the parties reach a mediated settlement agreement. There can be a preliminary opinion, a non-binding neutral evaluation, and the parties can agree that the SICC will be the forum of last resort where ADR processes are unsuccessful. Parties may also agree that the mediated settlement agreement can be directly enforced through the courts, or a determination can actually be binding through enforcement of the SICC. So remember, we can have different options for the same case. I think we're going to see more different processes going forward, and the multi-door courthouse and its establishment is the first step in that. Just one final point I'd like to make. All of us in this room are engaged in international commercial dispute resolution, and we now have frameworks in place, as I mentioned, for very objective standards of natural justice, and that's really important. But I want to encourage all of you to reflect on the idea that I mentioned from procedural justice theory, which is that the legitimacy of dispute resolution process is linked to parties' subjective experiences of the process. So when I was trained to be a mediator, we were taught to be culture wise and not culture blind. But I don't think that that same training and that same approach has found its way into other areas of dispute resolution. And I want to provoke all of you to consider a more nuanced approach to focusing on users in our field, including being more culture-wise rather than culture-blind, in putting yourself in their shoes as they go through the dispute resolution process. And we don't have to be stereotyped when we look at dimensions of culture. There are some fairly well-established objective dimensions of culture. I've used up my time, but if anyone wants to chat about them, I'll be available later and happy to share some of that data with you. Thank you.
Thank you so much, Senator. It's very, very thought-provoking, and we'll come back. I think to some of those issues. The timing is looking good at the moment. Thanks to Justice Shannon. But we are, as I said, privileged because we have access to real-world experience of the multi-door courthouse. Lagos, Nigeria, has led the way, as we've heard, over the last 22 years on this. And I mean, I wonder if you tell us a little about the foundation of the courthouse and how it's worked in practice.
I should start sitting between judges, just James and myself, who are non-judges, to say a huge thank you for the invitation. The starting point, I think the Chief Justice has almost given half of my prep, which is great. And I can then move on to more substantive issues. The question really is, what is it that disputants want? And how do we know what disputants want? How do we find out? And that's the need for evidence, evidence-led actions and movements. And that's what we've been hearing about. The difficulty I have with some of the data and some of the evidence is that we effectively transpose evidence from another jurisdiction onto other jurisdictions, which are not alike, and they're not the same. And so some of the things we're talking about on this panel, we're talking about informed disputants, or disputants that actually have legal representatives that they're actually paying. So hopefully the legal representatives know what they're doing. We're not talking about uninformed disputants who maybe are not corporations. And so we're talking about international commercial transactions, the big money, where the big disputes are. I think that's important to distinguish between those. Because the way the Lagos multi-door courthouse was conceived was more on the lower scale. Looking at, you have tenants, landlord disputes, you have small disputes. And the reason is, again, for us, the courts is not a question of congestion of courts, which was the Pound Conference, their major concern, and the major concern coming out of the US jurisdictions for appropriate alternative dispute resolution mechanisms. For us, it's actually a question of delay. So you have a tiny dispute, you're not paying much because going to the court is very cheap. You never ever get all your money back. So it says you have that, but you're there for the rest of your life or the rest of the life of your children and grandchildren. And so the question then becomes, for us, is how do you cut down on the delay? Because as we all know, justice delayed is effectively justice denied. Why would you go through the court process over 15, 20, 30 years? And by the time you get to the Supreme Court, you can't remember what brought you there in the first place. And so we need to appreciate, because of course, if the problem or the gap is different, the solution needs to be different. And maybe that's why for us in Nigeria, for example, when I say for us in Nigeria, I am Nigerian. I live in the UK, I work in the UK, but I'm very Nigerian. And that's why I say anywhere I speak, I make it really clear that I am very Nigerian. So for us, the key, if you like, the mischief was the delay. And why keep all of these very simple disputes within the justice system, a justice system that is broken, that is not efficient. In the UK, if you have a big case, I'm looking at Michael, if you have a very big case, you can get your matter sorted. You can get to the Supreme Court within a year and you get the decision. If you have a small case, you can be there for 5 years. That's okay, it's small, but we need the money. So the psychology is different. In Nigeria, whether you have a big case, you have a small case, it's tiny, you can be there for the next 20 years. Again, the psychology is different. And why I'm pointing all of this out is that the solution will be different. It's not a one-size-fits-all. We've heard about the DIFC courts, and we can see how efficient they are, and their goal, attracting more international work, so that their solution would be slightly different. The way they would operate, the MDC, which is the multi-door courthouse, will be different. They may, as they have chosen, they have specialist courts. But I was at a conference in Nairobi and I was pushing for a specialist court for an arbitration court. And the Attorney General then stood up and said, do we know how much it costs to set up a division of a high court? And that just brought it home to me that, states have different other considerations. And so for us, what we looked at, having laid that background, what the courts needed to do was, how do we get the vast majority of all of these very low value cases out of the system, and so that they can actually be mediated? Because most of them were suitable for mediation. And again, because in arbitration, you do need an agreement. And so what the courts then did was, underpinned by legislation, by statute, we have what they call an ADR judge. Doesn't matter what the A is, but it's usually alternative for now. We haven't gotten to appropriate the ADR judge. And the ADR judge does what Dr. Shamlan was sharing with us. So the ADR judge will look at it and determine whether this is suitable to go to the multi-door courthouse. The vast majority, as in 95 thereabout +% of the process that the multi-door courthouse adopts is mediation, which shouldn't be surprising. And the vast majority of that actually settle. And you can understand why, because they're very low value disputes. And when you have the very high value disputes, the judge can suggest to the parties, the judge can suggest to the parties, you can go to arbitration. You can enter into an arbitration agreement, because the law in Nigeria does not allow the judge, you can't force parties to go to arbitration. But it's not a principle, if you like, because under the Ghanaian law, the 2010 ADR Act, the judge can actively ask you to go to arbitration, which is really very interesting dynamics, because I can't imagine you being before Justice Shamlan or Justice Black, and he says, I think you should go to arbitration. I can't see how you're going to look at either one of them and say, no, I'm not going to arbitration. So you're like post consent. Of course, we will go to arbitration. We'll go and try it out. But it is actually helping. The problems, I think it's important that we don't, I don't want to leave you with the impression that this is a panacea, solves all problems, but because it doesn't. There's certain cases that are the parties just cannot agree, and they would not go through mediation, but at least they've been given that opportunity. Then they go back to the courts. And that is fine, because they understand, well, I've made a choice here, so I'm going to go through the system, and that is okay. The other thing I want to quickly pick up on is cost. It is so cheap. It is unbelievable. It is very cheap. Again, because of the starting point. One is the mischief. Low value disputes, get them out of the way, get it done. So high value disputes, And we have research to show that a lot of parties have problems with costs in international arbitration. But again, it's a question of choice. I think it's important. Sometimes we sort of get fixated with what we read in the books, which is sometimes not real life, that parties actually want to get on with the arbitration. Anybody who sits as an arbitrator will tell you, well, maybe that they really want to get on with it. They don't want to pay lots of money and all of that. But maybe there's research to be done, because it's really not true. In some cases, it's not true. In some cases, the parties are happy to drag things out. So I will stop there. I thought you were going to give me a sign. So, I will stop there. I'll pick up questions.
Well, we're going to have time, I think, for discussion and debate too. A couple of points just arising out of what you said, which we will go on to discuss in a minute, and I think is something that James wanted to address too, which is this, but one sort of one slight war story is only in looking at your, if I may say, magnificent CV, and reading the list of publications.
He phones me.
Yeah.
Sometimes I'm like, am I sure? But he phones me.
In reading the list of publications, I saw that you had written a paper some years ago on a case called IPCO and the National Nigerian, yes, NMPC, in which I appeared. And just to underline what you said about delay, we had evidence from the former Chief Justice of Nigeria. That was a case about an arbitration challenge to the Nigerian courts. And his evidence to the English courts was that the challenge procedure to the arbitral award would take 40 years. Which was quite interesting, because an English court held, as you know, that Nigeria was in breach of the New York Convention, and then decided the challenge themselves, which and that's another sort of doctoral thesis, I guess, that one. But the other thing that I think arises out of what you said was about the Lagos court really being directed to smaller claims. And of course, in the DIFC, we have the Small Claims Tribunal, and we have a mandatory consultation, and the registrars, the SID registrars will tell me, but I think we have something like a 90% success ratio on that, which actually brings me, James, to something that I know you wanted to discuss, and it's quite interesting in the context of something that the Chief Justice said that I didn't know you were going to say, which was whether or not ADR, however you term it, should be made mandatory, particularly in the larger cases, or whether you should just lean on the parties to do it. So do you make it opt-in, or do you make it mandatory? And I mean, if you also have some experience of how that's been dealt with in the region, that would be fantastic.
Oh, thank you. Obviously, all of the people in this room are rather, and this dais are rather sophisticated practitioners, judges, and users. But in the region, there's been quite a bit of success with mediations going through national platforms like Qadadi in Saudi Arabia, and also through the courts in Bahrain, and also through the courts in Saudi. But this question of opt-in or mandatory, I'm a big believer in whatever gets people in the room. I think the courts should be flexible, or at least the mediator perhaps should be flexible in terms of maximizing the opportunity of settlement by considering perhaps postponing or delaying the actual mediation if the parties require it. Because on the larger matters, sometimes there's considerable legwork and research to be done by the council, by the parties, in order to be properly prepared and to get the right people in the room. Because if you're going to have considerable authority, you have to have a considerable case to present to the board or the management team to justify the people in the room and to justify what authority they have in order to effectuate the settlement. So when you've got these opportunities for a mandatory regime, they have been successful in places like Canada, where we started those in the 90s, in the United States, similarly, Australia, and His Excellency, the new Chief Justice, pointed out how keen, and himself, a mediator, is about this mandatory element. I think that yesterday, during a mediation roundtable session we had here at the Dubai Arbitration Week, there were some people who had suggested that occasionally there are parties who show up and are only there because they have to be there, and they aren't necessarily going to do much except either tick the box to go back. That honestly is pretty rare in my experience, and also from what I've read from all our peers in terms of mandatory regimes around the world. I think that, as I said, I think the flexibility has to be there because some matters require more work and preparation, more parties, more experts, more reports and so on to be completed. So as soon as the parties are ready, I think mandatory mediation certainly helps. I can tell you that also it drives a lot of legitimacy and awareness, because in the UK, these regimes have done very well in getting people accustomed to it. Obviously, in-house counsel played an important role, because one of the first things I did with a Canadian bank when we were setting these up many years ago, they had room similar to this, probably twice as many lawyers from across the country. And the general counsel from this bank got up and said, right, we're not terribly happy with how things are going. James, can you explain how we're going to improve things moving forward? And I got in front of the room and thought, well, now I'm the most loathed man in the room. Thank you so much, Doug. And I sort of went from there. But the fact was that because the bank made clear, and all the banks were required, they were being encouraged, that basically the banks have been told there are small and medium-sized business disputes coast to coast. You either self-regulate, mitigate, introduce ADR, introduce ombudsman programs, or will legislate. The banks, of course, opted for that. Now, in this region, all of the governments and ministries have put in place some form of legislated mediation law. They've put in some form of training mechanisms. One of the things about mandatory programs, and typically, even in this region, not in places so much like Turkey, where you are not required to be registered with a body. If the parties are sophisticated and decide they want any particular neutral, they can pick that person based on their own preferences. So I think you have to have a roster of people, because with any mandatory program, because there will be people who don't know who to pick. There will be counsel might be new to the process, what have you. But for persons like us and His Excellency and others, the cases that are coming our way are with parties who are very sophisticated, very well represented, have substantial claims and so on. But I think mediation has worked very well, whether it's mandatory or opt-out. There are occasional situations where you have to allow, this is allowed, for example, in Italy, where you can opt out. You can, if the parties agree, they don't need to proceed. But that's a pretty rare thing, that the parties would agree anyway on anything, but also that they would be willing to forego this opportunity to sit down and review the matters in contention. I think that there are also mechanisms, and most of the, in the GCC in North Africa and Shams region, most of the legislation, most of the regimes allow the suspension of whatever processes are going, it's litigation or arbitration. That's very important. I think you can incentivize people if you bring in an element of costs. So if you settle early, you get some of your filings back, as was pointed out by Al Radi yesterday in the case of Bahrain, but also that you can also go even further, where if parties do not take advantage of offers proffered in negotiations, that there's some element of costs associated with that. So I think there's no question these programs in the Gulf have high settlement rates. Places like Jordan, they do extremely well, and they're introducing them more and more. So there are regimes that are put in place in schemes with industries more and more, and several of the banking groups in different countries in the region are evaluating these, but also consumer claims, larger claims, claims related to telecommunications are regulated by mediation schemes in places like Bahrain. So there are a lot of opportunities, a lot of platforms, and I'm a firm believer that whatever gets the people in the room will get it done, inshallah. So.
Well, yeah, I've got it working. Thank you. Not very impressive for a judge who has a technology course. We've got quite a good amount of time for questions. I hope that we will have a debate going about these issues. I'd also be very grateful for those who have experience in particular jurisdictions, whether they're mandatory or otherwise, to share with the room how it's worked in your jurisdiction. So can I invite any interventions from the floor? Sir, yes. So there's a microphone on its way.
My name is Javed Ahmed and I'm barrister and MCR by profession. You were talking about the other jurisdictions. A lot has been said about the mandatoriness of the ADR. In English CPR, there are provisions that, first of all, you have to offer the ADR, any support of the ADR. And then there are cost consequences. Part 36 of CPR specifies that if you are not going for the mediation, negotiation, or arbitration, prior to knocking at the door, you have to bear the cost consequences. I'm afraid this is sort of regulation, the rules are not here in the DIFC.
So you think that we have the new mediation centre coming, and what I think I would certainly like to learn from this room too is how you feel that we should be structuring that. I don't know if you want to say something about that.
Just some follow-up points from that and what James said about mandatory mediation. I mean, there are lots of pros and cons for mandatory mediation. One of the challenges I think can be that the mediation under the mandatory scheme may be taking place too early before the dispute is ripe. It can be at a very early stage and it may have a better chance of success later. One step before mandatory mediation might be, and I mentioned that business users in one particular survey has overwhelmingly been in favour of arbitrators facilitating settlement, which could be as minor as saying, have you thought about mediation? One way that courts could interact with mediation would be to say, for a judge to say, and I'm just raising ideas here for discussion purposes, this looks like a case where that could be very suitable for mediation. Why don't you consider it? It could be stronger than that. With the example we've given, it could be, I strongly suggest the parties consider mediation. So it's one step before mandatory. Another option is cost consequences, but really a very strong steer from decision makers, be it judges or arbitrators, that mediation is appropriate. And quite often, if you are the decision maker, you can see the deal to be done.
Yeah.
Do you ever have that as a decision maker? You can see that there's an opportunity, if the parties are willing to talk, for a deal to be done, that you need to help them be willing to talk because they will not take the first step. There is still, for some, this misconception that if I'm the first to suggest settlement, then I'm going to look weak. I think sometimes it can be overstated in the literature as an obstacle, but I do think that we could have a role to play potentially as decision makers, just giving them the idea and suggesting it.
Yeah, sure. I just want to comment on that. Within the DIFC Court practice, even before this mediation rules coming soon, we have the small claims tribunal. And the small claims tribunal, there is a limit if you are disputing over 1 million dirhams. So we'll have 2 stages. The first stage will be consultation, where it's like a mediation, but it's a court mediation. And even there's encouraging because a lawyer is not allowed to attend, and the party will represent themselves. So there's 0 cost. Then if the consultation fails, then they go to the second stage where they go for hearing for the same tribunal. So, and the percentage, as Michael says, the 90% is settled at the small claim tribunal. So we do have people.
I think since Michael is looking for suggestions, I would suggest that the Dubai courts do not make this mandatory, just because of the level of sophistication of the parties that appear before the court and the fact that for small claims, the process is clear and it's almost mandatory, at least it's there. But I would strongly suggest and agree that the courts should suggest. It's either a little stare, a strong stare, a medium, whatever. And when you also sit as arbitrators, do suggest to the parties. And I think for us as arbitrators, by the time all the pleadings and all the documents are in, I think if we suggest at that point, parties will take us a little bit more seriously.
Yes.
The problem we have is it's a bit too early because you don't really know much about the case. You haven't received all the documents and the pleadings and all of that. And usually for arbitrators, you sort of get a sense who's representing, or the lawyer that is recalcitrant, that feels my clients have a very good case, we're going all the way. And sometimes they might have blinders on because what you're saying on this side, they can't see. The last thing I want to say is again, we need to be careful when we have a state party or a state agency, because that's a completely different type of disputant. Remember that in democratic countries, for example, we have election cycles. And so, the current government might just say, it's not my problem. It's going to be the problem of the incoming government, so why should I settle? And then we have, of course, the big C. And for some states and state officials, if they begin to talk about negotiation, everybody's up in arms. Oh, money is going under the table somewhere, yes, and things like that. So those are legitimate concerns that such public bodies would have. And I think the court needs to be sensitive to that as well.
James, you want to say thing about timing, because in places like LA County or in Toronto and elsewhere, they give you prescribed time limits. So they say 6 months, you have to mediate before and so on. But the mediator has discretion in terms of, if the parties submit to the mediator that they need more time, the mediator can extend. There's another thing outside the court, which is a number of law societies, bar councils, and so on, have instituted requirements that lawyers are required to brief the parties about the process, about the options, about the different options, and specifically mediation. And that, I think, has played a big part in terms of promoting the use of mediation, because the parties, if their lawyers are suggesting it has utility and efficacy, that's very compelling for them. So I think we should have the bar and others.
And law schools.
And law schools are very important, very, very important.
Thank you very much. And Dr. Lam.
Yes. Good morning, Justice Black. Thank you for this wonderful panel this morning. Interesting discussion. Since we are talking about suggestions/recommendations, and being proud Lebanese coming from a country under stress in which the judiciary is nearly inactive, I would suggest that the UAE government signs some bilateral treaties with countries like mine, in which they will facilitate the enforcement of the judgments rendered either by DIFC courts or HGM courts, especially that such courts, they apply common law and we apply the civil legal system. Having such bilateral treaties will facilitate things and will give us a high advantage because of the efficiency and the time frame that is given in those courts to render judgment, which is very small, and it sometimes overrides arbitration itself. So this is a minor suggestion/recommendation for the UAE government and for the esteemed panel and the esteemed judges to carry it. Thank you.
Justice agreed. Yes.
First, let me congratulate the panelists for such a lively discussion, and you have really thrown open many questions, and which are to be answered and which are to be debated. Since Michael asked for experiences of different jurisdictions, let me share in the context of compulsory mediation my experience of what in India we have undergone through. And in 1989, we amended Code of Civil Procedure and introduced mediation as a process. And as it happened, and it normally happens whenever some law is passed, so there's one or the other litigant who is there to challenge the law, because Indian Supreme Court or even the High Court has the power to quash or set aside the legislation if it is unconstitutional. Anyway, so this amendment of introduction of mediation was questioned by one bar association in Tamil Nadu. This is called Salem Bar Association. And since they thought that with the introduction of mediation, their profession is, their bread and butter is at stake. And to cut it short, the Supreme Court ultimately dismissed that petition. Of course, it had to be. And but at the same time, said that the mediation, this was one of the arguments in that petition, that you can't force upon any of, because Section 89 did not talk only of mediation, but of judicial settlement, of arbitration and other. When even when the matter is in the court, the judge can say that, look, this case can go for arbitration. This is something like multi-court. This is what we are discussing. But then what happened, that in respect of mediation, the court said that you can't force upon, but the parties may agree. And what was suggested, that the parties, and both of you, that the court can advise, or court can suggest the parties to go for mediation, and that is what we call court annexed mediation. Even when the case is filed in the court, it goes for mediation when the parties agree. Initially, the parties were reluctant, but let's say in last 17 or 18 years, it has really caught up, and the people have understood the advantage of mediation and are going for mediation. Then in 1996, Arbitration and Conciliation Act, when it came, there's a very interesting provision that even when the matter is referred to arbitration, the arbitrator can, with the consent of the parties, can explore the possibility of mediation. The arbitrator can refer it to the mediator, or if the parties agree, the arbitrator can himself or herself initiate the mediation. Then in when the Singapore Convention on Mediation was signed, India was also one of the first signatories. We started thinking about the Mediation Act has to. And one of the questions was, and there was a provision in the Act also, that compulsory mediation may be there. Before that, in some legislation, like our Commercial Court Act says that if a commercial dispute is of a particular value, mediation is compulsory. You have to undergo the mediation before coming to the court. And so this was one of the issues, or one of the topic discussed, whether mediation should be compulsory or not. But ultimately, after the Act was passed, mediation as a mode of compulsory, adjudication process has not been agreed upon for various reasons. And one reason was that in India, you know that there are cases, we have 30 or 40 million cases today. So and every year, 10 million cases are filed in the courts. So if we make it compulsory, then for 10 million cases, first, if these cases have to go for mediation, where are the mediators? Where are the systems? So what is happening in the court may not happen at mediation. So these are our personal difficulties. But what I suggest, when it comes to going from this experience, that yes, there can be court annexed mediation, where the suggestion can be in the multi-court house. And then when the parties come, then it can be suggested that yes, you go for mediation, and there can be a system of court, this med-arb, med, etc. So this is another thing which can be introduced in the process. And like in our mediation, Arbitration and Conciliation Act, that even the arbitrators are facilitators, and they are encouraged to go for mediation. In my experience, I've retired for now little over 5 years. At least in 6 or 7 cases which are referred to me as arbitrator, I could mediate and settle those cases.
Can I ask one question? I'm sorry.
Yeah, I just want to say 2 really quick things. One, when I visit the courts in India, the first time I was in Delhi, and they said, we want to show you, because I was visiting the Supreme Court in the arbitration, that we want to show you the mediation. So we went across the courthouse. and there were people as far as the eye can see in every direction. And I said, "Oh, is this a gathering of some type, a demonstration?" I said, "No, these are the people here to mediate today."
Yes.
And I said, "Oh, and how many of these do you do a year?" They said, "Oh, we're down. I said, "Oh, how many?" "Well, 980,000. Oh, well, and how long are these? It can be 9 minutes or it can be 2 hours. It just depends on the case. So number one, they're doing, and they said, "We're very embarrassed because these other cities are ahead of us." So India is doing tens of millions of these things, which
Yeah,
is incredible, and they're effective, and the parties like them. The second thing is I did master classes with the mediators of the Supreme Court in India. These are extremely skilled people. Very experienced, very sophisticated, doing great work. So bravo to the Supreme Court of India. Sorry.
Thank you.
Just ask just
Yeah,
a quickly,
please.
quite a controversial subject, arbitrators being mediated. And I think the controversy arises from any confidential discussions with either party. So when, in your experience, is that part of the process when you arbitrate and then you're asked to mediate? Because then it might be problematic if you go back into an arbitration and there have been confidential discussions. Quite often arbitrators facilitate, but all in a plenary session without any confidential discussions. So I'm just interested.
As I said to you myself, the provision very clearly says, if I suppose matter is referred to me as an arbitrator, because we have a lot of ad hoc arbitration, where the courts appoint arbitrators as well, section 11, where, I mean, it's not an institutional arbitrations and parties are not able to agree on a particular arbitration, then the petition has to be filed in the court, and court can appoint an arbitrator. And sometimes sole arbitrator appointed by the court, or it may be arbitral tribunal consisting of the parties. Suppose the arbitrator, say, let us take an example, it is a sole arbitration, and the arbitrator feels that the matter is more apt for mediation, it can be settled. Now, as I said, normally it would be the arbitrator can say, okay, go to X or anybody, and you can mediate, and some procedural, I mean, guidelines, etc., are given in the procedural order. Or, as I said, coming to your question, only if both the parties agree that no, we are asking you to mediate. So then that arbitrator can act as mediator. But what the challenge is in order to assuage your apprehensions, which are, I mean, really substantial, in order, if we suppose the arbitrator.
I think there's some other questions, not that I want to cut.
Yeah, no, I only one sentence that this, if arbitrator is not able to settle, then he can accuse as arbitrator and can say that now you can go to some other.
Thank you so much. But I think Amelia, and then I think Andrew Miller wanted to say something, and then first next time.
Just a quick point, again, going back to cultural differences. So this whole idea of when you're sitting as an arbitrator, you can't mediate because of caucusing, it's very Western. I think it's important to keep that in mind, that in other crimes, it is perfectly okay for the same individual to mediate and then put back their arbitrator.
That's been the case in China for a long time.
Exactly. But the key thing, I think, it's the person doing the arbitrating and mediating. It's for you to ensure that you can still remain impartial and independent. And the last thing I wanted to say, hopefully Andrew will pick up, I don't know what you want to say, but maybe, is that we do need to rethink the way we teach law. Remember, I'm an academic, not just an arbitrator. We need to rethink the way we prepare future practitioners, because we basically prepare future practitioners to end up in litigation. And so when you're looking for you have 10 million cases that you need to arbitrate, who's going to do it? And the last thing, of course, I know we're going to come on to that because we have to talk about technology. We have a digital.
Well, Andrew, I know that we've, I say we, that the UK has recalibrated, or England has recalibrated the balance recently. It'd be helpful to learn perhaps about how that has been practiced. busy mediator and not.
Two of you have challenged me to talk about what you want to talk about. Really happy to do that. Can I just say thank you very much for calling me. Thank you for an excellent presentation, everyone. What I'm sure about, I'm a barrister by trade. I now mediate full time and haven't become neutral. I now seem to be appointed to arbitrate as well, but mediation is my mainstay. And what I find really great, it's the first time I've been coming to Dubai to work since 2013. It's the first time I've attended Dubai Arbitration Week, and everywhere I go, people are talking about mediation. And I think that said something. I spoke at an arbitration event in India in 2020. That's when I met you, Sapna, January, February 2020, and the then Chief Justice of India struck and said it should not be called an arbitration event, it should be called a mediation event. Because of what we need is mediation. And I think the key to this, I'll come back to the question, if as you have a multi-door system, you need to give people the keys. Because what I've heard, and I hate contradicting anyone, especially people on a learned panel, it's really easy. You know, I'm having been a barrister, having pulled up ladder, coach a term gamekeeper, I see things very, very differently. And what I see is we have to stop looking inwards and talking into this echo chamber, because it's what's behind us and they're the users of mediation. I talked about this a bit yesterday. It's people knowing about it. So in the States, a lawyer would not dream of conducting a case without discussing mediation and discussing the prospect of only using mediation before anything else. And that comes to the education point, because they're better educated in mediation there. So I think it's down to the users. What's happened in the UK, and I'm the trustee of the Chartered Institute of Arbitrators. So I've had a seat at the table for the last 2-3 years with the Ministry of Justice, trying to get what was originally called mandatory mediation, and they're now calling it integrated mediation. And that has now happened. And there was a very recent court of appeal case that turned over a 14-year-old bad decision, which said you couldn't mandate people to go to mediation because it was against the Human Rights Act. That's now been reversed, because if the mediation fails, you still have your right to trial. So that's in place. So we've been talking about this for the last 3 years, but what happened very, very fast after that case was a change to the procedural rules. And about, I think it's, ask the academics to tell me better, I think it's about 5 rules have been changed, but essentially at more than one stage of litigation, you have to think about ADR. I wish they'd said mediation, because it's almost always mediation. We have to think about it, and there'll be consequences. I can tell you, since that law's been in place, the change has been quite dramatic in terms of mediation bookings. So that's happening. But what's really happening is not the procedural change. It's not the court case. It's the lawyers realizing we now don't have a choice but to talk about mediation to our clients. I know that sounds awful. I've only got one hand, it's a cynical hand, but the shift is from ADR meaning an acute drop in revenue to actually being something that they use. As the Americans, my American friends and colleagues always say to me, I don't know why you Brits are scared of mediation. We saw it as another tool for us, another tool in the box, another string to our bow. And actually, as practitioners, I'm sure most of you here are practitioners, we saw it as a way to make money, because it is another form of dispute resolution that works. So it's giving the keys out and making sure the lawyers pass those keys to the client.
Thank you very much, Andrew. I think I saw a hand next to you. I thought maybe just time for the lady next to Andrew first of all, and the person at the back, please. Thank you.
I'm Lily from Arbitration and Mediation Center for Armenia, and I would like to thank our panelists for the very interesting discussion. And my question will be about the multi-tier clauses. So, for example, if the parties have the agreement that they should settle a dispute for mediation, and afterwards, if this fails through arbitration, Is it a practical issue? So one of the parties decides to apply for arbitration and not mediation, let's say. And in this case, in an MDC, my question would be, is this an admissibility issue or jurisdictional issue for the parties under the statute? Thank you.
Okay, do you want to answer that? And then we'll take the one last question.
Take the question first.
Let's take the question first. There's I think one more question at the back. So you would be kind enough. We'll take that, yeah.
Should I ask the question next?
Yes, ask the question now, and then we'll wrap up as everyone asks the question.
It's more of a comment, I guess, because we're talking about mediation, but you can't talk about it in a bubble. So if we're considering it, sorry, it's a Gordon from Hada. Thank you for the wonderful presentation. What I was struck with when I came to work in this region, I think 12 years ago, is really the reluctance of the end users to use mediation here. So the lady in front of me asked about multi-tiered clauses. When we try and put those clauses in contracts, we get a lot of pushback. And it is a perception issue. There's a bit of, in my experience, a perception that mediation is just adding time and cost. And from a DIFC court perspective, which often it's like an opt-in jurisdiction, so you have your onshore courts and you have your offshore courts. If we are going to try and sell the DIFC courts to our clients, I don't think you can have a mandatory mediation or arbitration requirement because they might perceive that negatively. It's a matter of educating the end users about mediation and positivity around it. So that's the first point. But then secondly, it's a matter of getting them to agree to DIFC court clauses. We do see them as, valuable and helpful in administering and resolving disputes. I think what would be most helpful from my perspective, yes, if we get an early enough indication from the judge or from the registrar about the types of cases that would be useful for mediation and a bit of a push in that direction. And then we've got something to go back to the clients with and say, look, this is what we've been told and you should seriously considering it. And then in that circumstance, the clients are not forced to do anything they don't want to do. But, there is a bit of a mandatory push that way. I think that would work well in this jurisdiction because other jurisdictions like say Australia where I'm from, it is more common to have mediation. In my experience here, it's not as common, and we're met as practitioners with a lot more reluctance from the end user. There's a lot of pro-arbitration section here, but mediation people are uncomfortable with, unfamiliar with, and they see it as a bit of a costly exercise, and often they say it's not going to resolve the problem. So it's, as I say, education plus a slight push. From my perspective.
Thanks so much, Scott. I'm going to try and before I throw it down, I'm going to try and, if I may, mash up all that we've heard into one big. And actually, I'd like to take Dr. Dazlal's point too, because about the interaction between different jurisdictions. Some of you may know that Bahrain has just signed, I think, an MOU with the Singaporean courts that there'll be a new commercial court in Bahrain, which will appeal to Singapore. Interesting in terms of sovereignty, in my view, but there are questions about that. But what I wanted to take from Dr. Salah's intervention and what Zagana is saying too is also the role of courts like the DIFC within the region to, if you like, promote and spread the knowledge and the understanding of things like mediation, which may not yet be fully on board with the some of the business entities in the region, and putting that in terms of the tiered clauses. Maybe that's also a way of promoting it. I know you want to say something.
No, I just want to make a couple of observations. First of all, Dr. Talal comments about, enforceability of the DIFC court judgment and order and liaise with other government. Of course, DIFC court judgment and order will be seen as a UAE judgment and will be enforced within the region under the Riyadh Convention and GCC Convention. The second point regarding the encouraging the mediation used within the young common law court. We have here in the room Amna Lawais, the Chief Registrar of the DIFC Court, and she can know this background better than me. When the decision making was with the Chief Justice, the first Chief Justice Anthony Vance used to be our Chief Justice, the idea of how much we're going to use mediation for the DIFC Court wasn't on the table because they want to build case law in the DIFC Court. So the mediation wasn't really that much, was being favored. Now the same thing with ADGM Court. They want to build case law. And I think this is the challenge with the young common law court. They always will think about mediation at later stage, even though at the case management system there is already a provision where party have to go for a while for consideration and then come back for litigation. The other things I would like to touch upon with, I sit as an arbitrator in one of those cases, and the tribunal was being challenged because the tribunal doesn't have jurisdiction because the post party haven't gone through the mediation stage first, and we ruled that we don't have jurisdiction because the party failed to go to mediation first. Yes, I lost my thought, so I think this is what I want to say.
Can I invite the other?
You put me under pressure. This is why.
Just to wrap up with their thoughts. I get ladies.
Oh, absolutely.
Yeah.
Okay, absolutely.
Anti-locking. Anyway. So I do agree with most of the comments that have been made, and I was also thinking of the Riyadh Convention, so that should be quite straightforward. I think what we do need to go back to is education. It would come. We've heard from the Chief Justice when this was introduced in Australia, in Canada, in the US. It wasn't an overnight thing because we are, we have a way we do things and we're asking for change. So it will take some time, but we have to keep at it and we have to continue to share our experiences. I think that technology would move things faster for us. And maybe that's something the Indians need to think about. How do you dispose of 10 million cases? And then, just looking at what eBay does, some of these cases is the same issues and they're quite low value.
It's interesting. Justice Shamlin and I attended the SIPOC meeting, Standard International Forum of Commercial Courts in Doha earlier this year. And we heard that in China, they triage cases with AI because of the vast number of cases.
And that's the future. That's the way we do need to go. But again, do keep in mind that the pace needs to follow that of the users, because we've been reminded that we need to put the users in the forefront. The last thing I would say is that we need to rethink our legal academic curriculum. It is no longer fit for purpose. So we do need to rethink that across the world, not just in emerging jurisdictions, especially in older, let me not say, older jurisdictions who are really set in the way they do things. We do need to rethink the way we teach law and the way we prepare the lawyers of the future.
Actually, in Indian law schools, mediation is not a compulsory subject.
Same in Singapore. So on education, I think that mediation in education is important. I think under the Singapore law, practitioners are also bound to consider ADR options. And James, you mentioned that that's the case in some other jurisdictions. From a DIFC context, maybe that's something to think about, given particularly what Zagona said about there being pushback from users. Maybe we need education at law schools, but also practitioners really selling this idea to their clients and pointing out what the benefits are. Just a final point on technology. In my view, we can have great success with an early neutral, non-binding evaluation going into a mediation. I think we've had a lot of discussion about whether we're all going to be replaced as decision makers by robots. I think it's safe to say that because of the way that AI works in predicting outcomes without reasons, that's not going to happen for large value claims. It can certainly work for eBay, but you could certainly potentially think about having early neutral evaluations done by AI to support the mediation process and support settlement, something to think about.
One quick thing on, you mentioned, Judge, about administrators, and several international ADR centers are required when parties file an arbitration to have, during their discussions with the lawyers, they explored mediation and what have they given, and this is offered, and to explain it all to them. So there's an administrative link. And about the sensitivity to processes, we were training Afghans as commercial mediators in Bahrain several years ago. And I asked them, what was the user survey like? And they said, oh, very, very popular. I said, oh, locally? Oh, 88% satisfaction. What about the international parties? Closer to 25. And I said, oh, can you explain the process to me? And they said, well, it's very simple. We appoint two gentlemen from the Chamber of Commerce to sit as co-mediators. They spend the day. If they don't resolve the matter, they withdraw. And within an hour or two, they will draft a binding decision. And I said, I think I know what the issue is. Because I think it's really important that the parties get what they expect. And when at the end of the week, they said, we'll change our program. I said, no. You might simply want to badge this traditional Afghan mediation. And then the other one, they can pick from a menu of services as to how they wish to proceed. So I think it's as long as the parties know what they're getting and they get it, that's fine. Consenting adults, as it were.
Well, thank you, and thank you. I'm afraid time has been our enemy here, and we're extremely grateful for the participation and the interest from the audience. I hope you gained something from it. I certainly did. And can I thank our panel members? And I don't know if the Chief Justice is still online, but can I thank him too?
Yes.
And if I would ask you to give a hand of applause to our